I want to talk for a few minutes about taking the high road. It's a phrase that I use a lot, and it gets a lot of different kinds of reactions. A lot of times the first reaction I get is, why are you telling me to be nice when it's clear based on what I've just showed you that my opposing party is not taking the high road, they're playing very dirty, and I want a bulldog lawyer who's going to retaliate and help me, do the same thing with more impact and get results here. So I have to clarify right out the gate. I'm going to do that right now. For me, taking the high road is not about being nice. You can take the high road and be very assertive and even aggressive in the appropriate sense of being aggressive with your legal position to set yourself up to win. Here's why I stress taking the high road, and here's what I mean when I say take the high road. When I say take the high road, I mean do it right. Do the right things in your case. If you have kids, do the right thing by your kid. One of the easiest things for me to reference, and there are a couple of different scenarios where this comes up, but is in paying child support. A lot of times I'm dealing with a parent who is the child support obligor. They're the one who is supposed to pay, and they're paying regularly, but the other side is withholding the child or playing games and obstructing that payor's parenting time. And so a lot of times they feel like their only leverage is to not pay child support or to do something retaliatory in that regard in terms of child support or child-related expenses because they feel like the other side's playing dirty and it's not right. A little quid pro quo. We have a long conversation about that. I've written about that, about why you pay child support. I encourage clients to pay child support even when there's not a court order in certain circumstances, and I have prevailed in child custody cases where I've had clients pay child support willingly without a court order. And I'm going to go off on a little tangent there. I think it will help illustrate what I'm talking about when I say take the high road. So I'll have a parent come in who has some circumstances, whether it's a criminal charge or something in their life that keeps them from having their child full time. So the other parent has the child most of the time. They don't have a court order, or they have an old court order that doesn't address everything. We'll talk about paying child support. We'll use some cowboy math and run a child support calculation and figure out what that client might pay under a court order, and then I'll have them pay. Here's why. If they don't pay, if they say, you know what, I don't like the parenting time situation, so I'm not going to pay unless I'm ordered to, then you're effectively giving the other parent a weapon. Parents who have kids and aren't receiving child support are effectively entitled to weaponize that, and they will use it as a complete defense for everything they do, even when what they're doing is wrong. So when you're paying child support voluntarily, you're taking away one of their biggest clubs that they can use against you. And I mean club like hitting someone. And you can also flip it. You can flip it potentially if the other side truly is guilty of misconduct and withholding the kid. You took the high road and paid anyway. Your lawyer can use that in cross-examination in court and say, you know what? He was supposed to have that weekend. You didn't bring the kids. And he paid child support anyway that next Monday, like he always does. And you can actually flip that, because judges know, even though you have to pay child support, you have a duty to pay child support. Judges know how people react. And so you can actually show the judge, I'm going to do the right thing, even when the other parent does not do right by the kid. So that's what I'm talking about when I say take the high road. Another example of this is in the discovery process. A lot of times we have a big disparity in the way we treat discovery and how the other side does. This is for a variety of reasons. Discovery is not taught in law school, and then lawyers tend to mimic one another. And 50 years ago, a lawyer came up with all these crazy objections that he put in response to discovery to try to avoid answering any questions. And so it's just copy and paste. Everybody else just copies and pastes those objections rather than do what they're supposed to do and answer discovery. We don't do that at my firm. So what that means, what that looks like is really lopsided, at least temporarily. If our client does what we ask, then they're going to produce a huge stack of data. And then a lot of times from the other side, we just get a few pages of objections, and we have to fight and claw for what they were supposed to do in the first place. Taking the high road means producing and doing what you're supposed to do even when you think the other side is not, or even when the other side has not, they've demonstrated they're not going to do it right. Is that about being nice? No. And that's sometimes a hard conversation to have with clients, because they say, why am I producing this? Why am I giving my bank statements when they won't even give their pay stubs? Why am I having to disclose all this information, and it's clear that they're not going to do this unless we're able to extract it using the judge? And the reason is this: because the judge doesn't know. In every case, each side, it comes in with the ability to claim and say anything. And we all know this as part of this. One of the hardest parts of our system is that anyone can say anything. And I try those cases. We'll go all the way through the litigation and mediation process and go to trial on a baloney case where the other side just says stuff that they dream or think or believe or fear or are concerned about. No evidence whatsoever. I try those cases. So it's a reality, and it's a dysfunction of our system. It's maybe a natural part of some of the best parts of our system, meaning that anyone that has a case can take that claim to court. We want that in America, but it comes with trade-offs. It means you're going to have bad, really weak, or terrible cases come in that shouldn't. So that's what we do, and that's what we have to deal with. But so we go into court, and the judge is trying to assess, who can I believe, if anyone in this case? Who can I trust? One of the things I stress in everything I talk about is credibility. Who can the judge believe and bank on when they say it, they've got evidence to back it up? You want that to be you. The only way to do that is to affect and think about how you handle things outside of court, so that when the judge is trying to assess who do I believe, they can look and rely on you because you did it the right way, even when the other side does not. One of the hardest things about discovery disputes is that most discovery disputes involve finger pointing. One side comes in and says they're not producing their bank statements. The other side comes in and says they're not producing their W-2, their financial information, a different set. And so there's this constant false equivalency of finger pointing and blame shifting where each side's complaining about something that the other side didn't do. We want to eliminate that. The only way to do that is to take the high road and to do what you're supposed to do. And by doing that, we create a big gap between what we're doing, following the rules, doing the right thing, getting ready for trial or settlement if we can settle, and the other side who's playing games, dragging this out, not producing and doing what they're supposed to do. Like I said, there are a number of scenarios where I'm going to say, take the high road. It's not about being nice. We'll make settlement offers even when we really feel like and have the sense or even told from the other side that we will never settle with you. We make those settlement offers as part of the process, as part of a risk mitigation and risk assessment to try to resolve the case, to show that we're reasonable. In family law, judges have really powerful fee shifting authority. What that means is when they assess attorney fees is at the end of the case. So they're reviewing everything in hindsight. The only way you can set yourself up to get attorney fees is how you behave months, sometimes even years before the judge is ever looking at your attorney fee claim. How do you do that? You take the high road. You meet your deadlines. You produce your information, and you make settlement offers and try to resolve your case reasonably. Sometimes that's not possible. Again, I tried those cases. Sometimes legitimate disputes go to trial. One side wins, one side loses, but nobody has to pay each other's attorney fees because they both behaved reasonably getting to that point. What you want to do is, in those cases where the other side is behaving out of bounds, you want to create the gap and show the judge that was them, it wasn't me, and I can show you by my conduct.